For Creamer Media's Polity, I'm Shannon de Rehove. I'm at Norton Rose South Africa's Johannesburg office to speak with Director Andre Vos about the nationalisation and expropriation debate. Even though the South African government has consistently opposed calls for nationalisation in South Africa, the demand has continued to be raised in some quarters. What, in your opinion, confirms the campaign for nationalisation?
South Africa still has a legacy of inequality. We still live with the after effects of apartheid. There is huge unemployment, inequality, as I say. Those are all statements that few people will argue with, but even fewer people will recognize those as the opening paragraphs of the ANC Youth League's document on the proposed nationalisation of South Africa's mines. That demonstrates for me the underlying issue. We have a history of inequality, unequal distribution of wealth. We have lots of natural resources. It's about finding the balance. So the debate really was fired up by the ANC Youth League's proposals, which is being looked at by the ANC itself. But it goes to show that there are underlying issues and valid issues that few people would argue with. So there is also resource nationalism on the rise internationally. The term resource nationalism can take many forms. In Australia, for instance, you see the issue around suggested super taxes on mining companies on the super profits that they make. It can be seen as another form of nationalisation. It's about how the state gets its fair share of revenue from natural resources.
What effect is the nationalisation debate having on investor confidence in South Africa?
It is hard to say. As I've said, you find around the world that there's increasing pressure on states to increase revenue. The world is in the middle of economic recovery. There's talk of another recession. So revenue to state coffers are under pressure. What investors want, though, are certainty. It's all about risk when you invest, and they like certainty. I think what the debate is creating is a measure of uncertainty. We all know that it won't be resolved until the end of this year, when the Mangaung conference takes place with the ANC in Bloemfontein, the end of 2012, and hopefully that will settle the issue of certainty.
Senior executives at the Chamber of Mines suggest that the nationalisation discussion be directed towards how the contribution of mining can be enhanced through growth and transformation. Can you comment on this idea?
Yes, the Chamber of Mines is a body representing the mining houses, so they have a certain perspective on matters. Of course, they would put a case forward that would be in the interest of the mining houses. So their suggestion of growing the pie, so to speak, through economic growth, would be creating employment. They would argue that if you allow investors into an investor-friendly environment where you have friendly mineral laws as opposed to nationalisation in its extreme form, which I will talk about in a moment, that from their perspective instills investor confidence, and it'll increase the pie, so to speak. What is not clear in the debate so far, I mean, it's a very emotive term, nationalisation, but what it means in law really is expropriation. And it's an international legal principle that you can't expropriate without compensation. And that's essentially the position in South Africa as well, and protected by our constitution as it stands. So you can't expropriate without compensation. So that in itself answers some of the questions. Will there be, what is the likelihood of nationalisation being implemented in its extreme form? I say the extreme form is where you expropriate all the mineral rights. It now belongs to the state, which is not the case at the moment. Under the MPRDA, the existing act regulating mineral law in South Africa, the state is the custodian. And it's not clear what that term means. It says that the natural resources belongs to the nation, and the state is the custodian, and they award licenses for people, mining houses and so on, whoever wants to apply. to mine those. If there's expropriation, it will be, those rights will be taken away and the state will become, presumably in that extreme form, the owner, but they will have to compensate. The measure of compensation is basically, it's more complicated than that, but it's market value or fair value. And that you're talking billions, if not trillions of rand. So one can't imagine the state being able to afford it. So what is the likelihood of that extreme form of nationalisation taking place? In my view, it is not a likely eventuality.
What do you expect to come out of the ANC study into mining policy and nationalisation?
It is hard to say, because you have on the one hand the more progressive elements saying that, or radical elements some would say, that there should be nationalisation in its extreme form. Although the ANC Youth League document is not by any means clear about what it means, what it intends the form should be of nationalisation. But you have the Minister of Mineral Resources on record over the past year or two repeatedly saying, I do not believe that nationalisation will work. What form it will take, one does not know. It is being investigated at the moment. It can take many forms. It can take the form of the state taking a majority share in shareholding in existing mining companies. Again, I think that's an unlikely eventuality. Or it can mean that the state will retain a majority share in the mining rights as opposed to the assets and the shares in the mining companies. Or it may mean an increased requirement as far as BEE involvement is concerned, or more onerous provisions as far as development and employment are concerned, social and labour plans, that sort of thing.
Legally, what amendments would you envision could be helpful to South Africa's mining law regime?
Firstly, there is an existing act which came into force 1st of May 2004, so that's now almost 8 years ago. That act in itself brought about quite a radical change in regime, where you had common law ownership of minerals. That was taken away, and now you have a license system which is administrated by the Department of Mineral Resources. So it is an administrative system in essence. If the existing act could be properly implemented and the administrative procedures around the act could be properly implemented by the DMR, that would go a long way, I think, to improving the whole situation around minerals and mining in South Africa. But at the moment you find that the DMR is overburdened. It cannot always adhere to its own administrative processes. So if that could be sorted out, I think that would already be a good start. Having said that, if there are any amendments to be made to the Act, again, there was a 2008 Amendment Act which was never implemented and is highly unlikely ever to be implemented because it has been overtaken by events. You're now looking at a new, more comprehensive amendment to the MPRDA. Presently advised, it looks like there won't be a bill for consideration before next year, so that the earliest you could see any amendments to the MPRDA would be by the end of next year, possibly 2040. What amendments would be helpful? I think the internal appeal process, which the Act presently requires you to go through if you want to object to the grant of any rights, or you want to review any decisions if your application for a right has not been granted or refused, you have to first appeal to the Director General of the DMR or to the Minister, depending on the nature of the right. That process is simply not working at the moment. Again, the DMR are simply not able to get through all the appeals. If that process is abolished, I think that would facilitate matters. The Minister has also talked about amendments that could streamline the application process itself. One of the shortcomings perhaps of the Act is the fact that there are not stipulated time periods within which steps have to be taken to process applications. Except for the environmental management programs, there's a 180-day period. For the rest, there are not stipulated periods within which the steps need to be taken. So if the Act is amended to take care of that and to stipulate periods throughout the Act, that would also, I think, bring certainty and facilitate the administration of the Act.
That was Norton Rose South Africa Director Andre Vos to discuss the nationalisation debate.